5 seconds to go. Start. At this juncture, we may also refer to the following observations made in the case of N. Harihara Krishnan versus J. Thomas Supra. The scheme of the prosecution in punishing under Section 138 of the Act is different from the scheme of CRPC. Section 138 creates an offence and prescribes punishment. No procedure for the investigation of the offence is contemplated. The prosecution is initiated on the basis of a written complaint made by the payee of a check. Obviously, such complaints must contain the factual allegations constituting each of the ingredients of the offence under Section 138. Those ingredients are that a person drew a check on an account maintained by him with the banker, that such check when presented to the bank is returned by the bank unpaid, that such a check was presented to the bank within a period of 6 months from the date it was drawn or within the period of its validity, whichever is earlier, that the payee demanded in writing from the drawer of the check the payment of the amount of money due under the check to pay, and such a notice of payment is made within a period of 30 days from the date of the receipt of the information by the payee from the bank regarding the return of the check as unpaid. It is obvious from the scheme of Section 138 that each one of the ingredients flows from a document which evidences the existence of such an ingredient. The only other ingredient which is required to be proved to establish the commission of an offence under Section 138 is that, in spite of the demand notice referred to above, the drawer of the check failed to make the payment within a period of 15 days from the date of the receipt of the demand, a fact which the complainant can only assert but not prove. The burden would essentially be on the drawer of the check to prove that he had in fact made the payment pursuant to the demand. By the nature of the offence under Section 138 of the Act, the first ingredient constituting the offence is the fact that a person drew a check. The identity of the drawer of the check is necessarily required to be known to the complainant payee and needs investigation and would not normally be in dispute unless the person who is alleged to have drawn a check disputes that very fact. The other facts required to be proved for securing the punishment of the person who drew a check that eventually got dishonored is that the payee of the check did in fact comply with each one of the steps contemplated under Section 138 of the Act before initiating prosecution. Because it is already held by this court that failure to comply with any one of the steps contemplated under Section 138 would not provide cause of action for prosecution. Therefore, in the context of a prosecution under Section 138, the concept of taking cognizance of the offence but not the offender is not appropriate, unless the complaint contains all the necessary factual allegations constituting each of the ingredients of the offence under Section 138. The court cannot take cognizance of the offence. Disclosure of the name of the person drawing the check is one of the factual allegations which a complaint is required to contain. Otherwise, in the absence of any authority of law to investigate the offence under Section 138, there would be no person against whom a court can proceed. There cannot be a prosecution without an accused. The offence under Section 138 is person specific. Therefore, Parliament declared under Section 142 that the provisions dealing with taking cognizance contained in the CRPC should give way to the procedure prescribed under Section 142. Hence, the opening of non-obstant clause under Section 142. It must also be remembered that Section 142 does not either contemplate a report to the police or authorize the court taking cognizance to direct the police to investigate into the complaint. The question whether the respondent had sufficient cause for not filing the complaint against Dakshin within the period prescribed under the Act is not examined by either of the courts below. As rightly pointed out, the application, which is the subject matter of the instant appeal purportedly filed invoking Section 319 CRPC, is only a device by which the respondent seeks to initiate prosecution against Dakshin beyond the period of limitation stipulated under the Act. In view of the above arguments advanced by learned counsel for the appellant that an additional accused can be pleaded subsequent to the filing of the complaint merits no consideration once the limitation prescribed for taking cognizance of the offence under Section 142 of NI Act has expired. More particularly in view of the fact that neither any effort was made by the petitioner at any age of the proceeding to arraign the company as an accused, nor any such circumstances or reason has been pointed out to enable the court to exercise the power conferred by proviso to Section 142 to condone the delay for not making the complaint within the prescribed period of limitation. Stop.